At the Umansky Law Firm, we believe everyone deserves a second chance.
So make sure that before you apply, that you've checked your background. If you've had prior criminal arrests or charges, or subpoenas to appear, or summons to appear, or notices to appear, or citations that you've gotten for criminal cases, make sure that you were not convicted or adjudicated. If you got them in another state, make sure you go back to that state, pick up the disposition of the charge, look carefully, and make sure that you're not convicted. What we do in our office is we'll take the certified disposition and application and the money order and the charging affidavit in some cases, and we'll put it all together in a package. We have a letter that we write to the Florida Department of Law Enforcement, and we send it out to their location. And because we do so many of them, we've developed a relationship with the Florida Department of Law Enforcement so that if something's missing, we're able to get it back quickly and address it. Or if there's a problem on FDLE's end requesting more information, we could try to handle it as quickly as possible. We'll send that information off to FDLE with the $75 check, or we'll use a trust check that FDLE will accept because they know it's from a law firm, and hopefully get that process moving so that we get that certificate of eligibility back. In many cases, we sometimes get that certificate of eligibility back under 60 days even, and when we get that certificate, we're ready to go. And what does that mean? Well, that leads us to the next step. So if you're doing this on your own, you're going to now create a petition to expunge your record. You can get a form petition in your local law library or sometimes online. But make sure that it's the right petition, the latest petition put out by the state Supreme Court. Because if it's an older petition and doesn't have the exact language that you need in it, believe it or not, the prosecutor will likely object to your petition being granted. And if it's a lawful objection, the judge will not grant the expungement of your record, and you ultimately will have to restart the process all over again. And like I said, you can get this form at a local law library or online. Sometimes the Supreme Court might have them on a database, but you can get that form and fill it out. One little trick that you may not know that is very, very important is that in some jurisdictions, the Supreme Court form is not good enough. And you actually may need to put in additional information as to why this expungement is important to you. You won't see it in the statute books, you won't see it in the rule book, you won't even see it in the form. But when you apply with that form and the state attorney gets it, they'll automatically, in some jurisdictions, object to it. It's crazy, I know. But there's something called case law, which, although the expungement process in itself can be relatively easy, there's case law that's decided by other judges over a period of time that have seemed to suggest that more information is required than even the Supreme Court and the rules of civil procedure have asked for. You need to put that information in there, because if you don't, the state will object, and there's a very good chance you won't get that petition granted.